Welcome to This Explainer. Today, we're going to dive right in and demystify the foundational rules of French property law. Whether you're currently studying law, maybe looking to invest in some real estate, or honestly, just curious about how society actually organizes its assets, you are definitely in the right place. Let's explore the fundamental building blocks of how ownership really works in the real world. Here's a quick roadmap of what we'll be covering today. We've got 5 main stops. First, the nature of goods. Second, the DNA of ownership. Third, how we go about acquiring property. Fourth, dismembering rights. And finally, legal limits and servitudes. All right, kicking things off with Section 1, the nature of goods and how we define these legal categories. To start at the absolute foundation, we have to ask ourselves a pretty basic question. What actually constitutes a good in the eyes of the law? You see, in French law, before you can own something, you literally have to know what kind of thing it is, because the rules change completely depending on its category. Basically, everything a person owns forms what's called their patrimony, and this patrimony is tied directly to your legal personality. It holds both material goods, stuff that can be sold or transferred, and non-material rights, like your freedom of expression. But for our purposes today, we're focusing strictly on those material goods. So in French law, there's a really clear binary split here. All goods are either meublé, meaning things that can be moved around, like your living room furniture or financial shares, or they're immeublé, which are fixed to the ground, like a plot of land, buildings, or even unharvested crops. But the law gets incredibly specific, almost quirky here. Goods can be movable by their very physical nature, meaning you can literally pick them up and carry them from one place to another, or they can be movable by the determination of the law itself. This includes things like financial shares, legal actions, and, surprisingly enough, boats and massive ships. On the flip side, immovable goods are naturally fixed to the earth, but you can also have immovable goods by destination. For example, if you place a tractor on a farm specifically to exploit that land, that movable piece of equipment suddenly becomes legally immovable. There's even a fascinating rule where a statue placed in a wall niche designed expressly for it is considered immovable, even if you could easily just lift it right out. And this brings us to a super fascinating legal duality when it comes to animals. A law passed in 2015 finally recognized animals as sentient beings. Yet, legally speaking, they were still primarily treated as movable goods, or even immovable goods if they're, say, livestock placed on a farm for its exploitation. For centuries, animals were literally just categorized as things. This modern legal update acknowledges their capacity to feel, but in order to maintain the structure of everyday commerce and agriculture, they technically remain trapped within the property regime. It's a perfect example of the law trying to strike a balance between modern understanding and ancient structural categories. Moving right along to Section 2, the DNA of ownership, or the bundle of rights. Now that we know exactly how goods are categorized, what does it actually mean to own them? Well, the right of ownership isn't just one blanket thing. It's more like a bundle of 3 distinct rights. Think of it as a 3-part DNA sequence. First, you have usus, which is the right to use the property yourself, like actually living in your own house. Then there's fructus, the right to profit from it. That means you can harvest the apples from your orchard or collect rent from a tenant. And finally, abusus is the ultimate right to dispose of the property. You can sell it, give it away, or even completely destroy it if you really want to. When you hold all 3 of these rights together at the same time, you possess what the French call pleine propriété, or full ownership. So, the absolutely crucial point here is that this bundle of rights has 3 fundamental characteristics. It's absolute, exclusive, and perpetual. The absolute nature is actually guaranteed by the Constitution, allowing you to use and dispose of things in the most absolute manner possible. But there is a catch. You can't make a prohibited use of your property. For instance, if you own a building that happens to be recognized as a UNESCO World Heritage Site, no, you cannot just tear it down or completely alter it without strict legal permission. Next, exclusive means you, and you alone, hold this right over the object, though of course you can co-own it with someone else. And perpetual is genuinely wild. Unlike a patent or a copyright that eventually expires, your property right over a physical object literally has no time limit. If you own a piece of land and completely ignore it for decades, guess what? You are still the owner, as long as that land exists. Let's dive into Section 3, acquiring property. And yes, this goes way beyond just buying and selling. When most people think about acquiring property, they picture buying a house or a car. But there are actually 4 main ways to acquire property in French law, and some of them are pretty surprising. Let's walk through them. First is accession, which basically means if you own a piece of land, you automatically own whatever fruits it produces, and critically, you also own the space directly above it and below it. Next is succession, which is automatic inheritance upon death. and that's strictly governed by complex family hierarchies. Then we have liberalités, covering voluntary giving, like donations while you're alive, or leaving something in a will. Though be aware, French law strictly limits how much you can actually give away if you have children, just to protect their inherited reserve. And finally, my favorite, prescription. If you occupy a property continuously, peacefully, publicly, and basically act like the true owner for 30 years, or just 10 years if you acquired it in good faith but with a flawed title, the law actually steps in and grants you full ownership. It's an incredible rule because it actively rewards the use of property over long-absent owners. Okay, on to Section 4, Dismembering Rights, where we legally split ownership wide open. Remember that triad we just talked about, usus, fructus, and abusus? Well, think of full ownership like a giant puzzle that can legally be taken apart. One person can hold the abusus with the eventual right to sell it, while an entirely different person holds the usus and fructus to live in it or collect rent until they pass away. This setup is incredibly common in French estate planning. The person holding the usus and fructus is called the usufructier. They get to live in the house or rent it out and pocket the cash. They do have to pay the property taxes and maintain the place, but they can't sell the building itself. Meanwhile, the person who holds the abusus is the new proprietaire, or bare owner. They hold the ultimate right to the property's core value, but they literally can't step foot inside it or collect a dime of rent while the usufruct is active. Once the usufruct ends, which usually happens when the usufructier passes away, the bare owner magically absorbs those other rights and regains plain propriety, or full absolute ownership. And finally, Section 5, Legal Limits and Servitudes, or what I like to call invisible boundaries. So, remember earlier when we said ownership is absolute but always subject to the law? Well, this is exactly where external forces and your neighbors can legally restrict your absolute rights. A perfect everyday example of this invisible boundary is a servitude de vue. This enforces incredibly strict distance rules for windows to protect your neighbor's privacy. A servitude is basically a charge imposed on one property for the utility of another property, and it permanently attaches to the land, not the owner. So if you sell the house, that servitude stays right there. You literally can't not just punch a window into your wall right on the property line if it looks directly into your neighbor's backyard. The law dictates minimum distances, usually 1.90 meters for a direct, straight view and 0.60 meters for an oblique, angled view. So your absolute right to build whatever you want on your own land is actually legally curtailed, just to preserve the peace and privacy of the entire neighborhood. Similarly, what if your property is completely landlocked, without any access to a public road? Well, the law steps in again and forces a servitude de passage across your neighbor's land to make sure you can actually get to your own front door. The property that desperately needs the access is called the dominant estate, and the property that has to suffer the pathway being built right across it is the servient estate. It's tough on the neighbor for sure, because the owner of the servient estate really doesn't have a choice in the matter. The law essentially forces this concession so that land doesn't become trapped and entirely useless. Though, to be fair, the burdened neighbor can at least be compensated with a financial indemnity for the massive inconvenience. Before we wrap things up today, it's absolutely worth knowing about the bail emphyteutic. This is a massive, long-term lease that can last up to 99 years, where the tenant actually gets real property rights and the benefit of any improvements they make. They are pretty rare today, but fascinating. You see, while a normal renter just has a personal contract with a landlord, the tenant in an emphyteutic lease holds a real right over the property for anywhere from 18 to 99 years. The tenant acts almost entirely like the true owner. They take on all the financial charges, and they can even build completely new structures on the land. But here's the absolute wildest part. When that 99-year lease finally expires, the original landlord gets the property back, along with every single improvement the tenant ever made, without having to pay a single cent of compensation for them. So as we conclude this explainer, I want to leave you with a challenge. Take a moment to look out your own window and see if you can spot how these invisible building blocks of property law are physically dictating the world around you. Is the distance to your neighbor's window the result of a hidden servitude? Is the very land you're standing on subject to a dismembered property right like Usufruct? The law really isn't just dry words in a heavy textbook, it's literally the invisible architecture of our everyday lives. Thank you so much for joining me today, and keep questioning the structures around you.